Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe, and I'm here live to answer your questions. Now, I would like to talk to you about residence in the United States, as well as getting a work permit. That is the most common thing. Even if you're living here and you don't have that, if you have temporary status or you don't have any papers at all, there are still ways to apply for permanent residence in the United States, and I'm here to answer those questions. You can ask me anything that's immigration related tonight. That's why I'm here. I'm here to primarily prioritize your questions. So the topic I'm going to be talking about tonight is how to apply for permanent residence without marriage, because that's another common one that I hear about. How can I do it without marriage? Now, for some individuals, that they don't have a spouse and they don't have any connections at all, their options are going to be limited. So that's the first thing I want to let you know, but I'm going to explain some of the ways that you can still do it without necessarily being married to a U.S. citizen. Or even a legal permanent resident, because keep in mind you still can qualify for permanent residence through a U.S. permanent resident. So how do you apply for permanent residence without marriage? Now, first, let me remind you that I'm here to answer your questions, so don't hesitate to put your questions in the comments. I want to get into the habit of putting those questions in the comments as soon as I come on, because that's a good way to share information. It's a good way when you ask your questions, and there's no such thing as a dumb question here. I'm pretty sure that there are other people who are listening to this live that want to ask the same thing, or they're going through the same thing and they want to know the answer. So U.S. citizen filing for unmarried son over 21 time frame. So that is taking us longer. It's 6 to 7 years right now, unfortunately. Now, keep in mind that if you are in the United States and you're without status, that there is the waiver process, where if you have to do it through your parent, your U.S. citizen parent, and your U.S. citizen parent will experience extreme hardship if you don't get the permanent residence, there's a waiver that you could apply for. It's like forgiveness for the overstayed that will be able to allow you to leave the country when it's time for the interview and to complete the process at the embassy in your home country. If you have follow-up questions, go ahead and put it in the comments. So don't hesitate to keep those questions coming. This is a really good question. Now, how can you get permanent residence without getting married? So the first is employment. There are different types of employment-based permanent residence, and it all depends on what your qualifications are. The types of employment-based green cards range based on your qualifications, what are the needs of the employer, and what are the needs of the country as well. Hi there, I have applied for my husband in 2020, but his green card, he is in India right now. So if you are a U.S. citizen or even a legal permanent resident, then that process should be going through. It's taking about 18 months to even 24 months. So keep that in mind. Be prepared for a process that could take as long as 24 months. But the average time is 18 months, especially if you're a U.S. citizen. Now, if you are a green card holder, Priyanka, I do have good news for you. You did apply at the right time, because applying for the spouses of permanent residents are not, they're not on a wait list to get an immigrant visa number. That's usually what takes the most time. Right now, as soon as you have to wait, of course, for your petition to be approved, but as soon as it's approved, it goes to the National Visa Center and they start processing your case and preparing it for the interview. What normally happens with other cases that takes a longer time is that once the petition is approved, it goes to the National Visa Center and it sits there and waits until you can get an immigrant visa number. So does the time frame depend on the state the citizen lives in? And would it affect my B1, B2 visa if my dad files? So no, it's not based on the state. It's based, so what happens is that they can only give a certain amount of immigrant visa numbers per year. And at this time, so many more individuals are applying for as adult children of U.S. citizens that it's taking a long time. So it's basically a 6 to 7 year wait list. So that's what's happening, and it has nothing to do with the state that you're living in. So keep that in mind. And would it affect my B1, B2 visa if my dad files? So that's my least favorite question. And the reason being is that yes, it can affect it. So if you are coming into the country or you go to renew, and they do see that you have an immigrant, you have a petition that's pending on your behalf, then it could possibly affect it, and it could possibly affect their decision to issue a renewed visitor's visa. However, I've also seen cases where when the case is taking a very long time, so it's taking a couple of years, and they know that it's going to take a couple of years to be processed, that they still go ahead and renew the visa and allow the relative to come into the US. So it all varies, and it really depends. Can you please tell me what is the difference between Vermont Center and then, so there's a National Benefits Center and then the Vermont Center. So the National Benefits Center probably processes other types of, certain types of cases, and then the Vermont Center processes, they're assigned to other cases. So, but then NBC is the National Benefits Center. So keep your questions coming, because I am here to, so it's not, so the National Benefit Center is not necessary, it's not a matter of it being good or bad. So it is, they're just processing your case. So if you see National Benefit Center, it doesn't mean that something bad is going to happen. It just means that they're currently doing something with your case or processing your case. So keep your questions coming, because I'm here to answer your U.S. immigration related questions. Now, as we are between questions and information, I want to formally introduce myself. For those of you who don't know me, I'm U.S. immigration attorney Sharifa Tharpe, and I help clients to get their green card and status in the United States. And I also come on here live every night at 9 p.m. So before, I would not come on a regular basis. I mean, I would come every day, but I would come at different times. Now I have a set time, and it's 9 p.m. every night. How long 601 waivers take if spouse is American citizen and it's for his overstayed wife? So right now I've seen them as, if this is an I-601, so it seems like an unlawful presence waiver, I've seen them as short as 6 months, and unfortunately I've seen them go as long as a year and a half. So it really depends. What you can do is, if you go to the USCIS.gov website and you go to the you find the service center that is processing your case, then, and you look for that I-601 form, see how long that particular service center is taking to process your case. So keep your questions coming, because I'm here to answer your immigration related questions. So put those questions in the comments, and I'm going to go through your questions as quickly as I can. So what if I am on an H-2B visa and change it to a B-2 visa, then come home? Does that affect me going back? So you definitely would not be able to, so when you have a B-2, now if you change it to a B-2 status, that's not necessarily a visa. So you'd still have to go to the embassy. So when you're in the US and you change from H-2B to a B-2 status, that is not a visa. And so as soon as you leave the country, you're going to have to go back and get an actual visa at the embassy. But, you know, it's not necessarily, you just have to make sure that you bring your evidence, bring the same evidence, make sure that you did when you first got your B-2 Make sure you show strong ties to your country in order to make sure that you get that B2 visa. Hi, can a 61 years of age male who's on dialysis help his girlfriend to get a fiance visa? So yes, that is definitely a possibility. Of course, you would still have to show that you do have a genuine relationship and that you do plan to get married. You also have to show that you have seen each other in the most within the last 2 recent years before applying. If you can't, you have to show that there are exceptional hardships that prevented you from seeing your fiance. So for in this case, if you are 61 years old or the person is 61 and they're very sickly and they're unable to see them in person, and then the girlfriend may not have a visa, that could possibly be an explanation or a valid reason to get a waiver. What you can do is definitely schedule a consultation and we can talk more about what the situation is. Now, in order to file for a fiancé visa, you have to be a U.S. citizen. Unfortunately, permanent residents can't file for their fiancés. My question is, but my biometrics is in. No, so it's not bad. Jay Hind, it's not bad. Your biometrics, you often, when you're doing the biometrics, you're going to get that letter or notice from the National Benefits Center. You're welcome, Priyankas. I filed for my husband in April. How long would it take for him to get his work permit? So right now, you're looking at about 6 to 8 months. That's the average time. Keep in mind that this is general information and it doesn't necessarily mean that that's going to happen in your case. You might get it in a shorter time. However, the average time I'm seeing is 6 to 8 months. The embassy told me to come in for an interview. So Andrew Biggs, I'm not sure. Did you have a question? So yes, so exactly, because if you are going over to a B2, you would have to get if you're going to a B2 visa, you have to do an interview. So they're not going to change from one. When you're at the embassy, most times, if not all times, you have to go back and do the interview. U.S. citizen filing for a sibling over 21 time frame, 14 years dangles. So 14 years, unfortunately, I know it's taking unbelievably long. And that's the shortest period of time right now. If you look at, you're welcome, Jay Hind. If you look at Mexico, it's taking over 20 years. So it's unbelievably long. It's impossibly long. And, unfortunately, it's not a quick and easy solution right now. Hopefully something will change in the future. But right now, there is a 14-year-long wait list. So Anika, thank you so much. I am always glad to be here to end the night with you all and to answer your questions. You're welcome, Andrew Biggs. So keep your questions coming because I am here to answer your immigration questions. Now, if you want to learn more about me, you're listening, and you just know that you want personal legal advice, you can always go to the link in my bio, and there are various options there to click on. So you have the Instagram page to continue to follow me. By the way, if I am going to be heading over to Instagram at 9:30, and so if you want to continue this conversation or you want to continue to listen to the topic, then you can hop on over to Instagram and continue the conversation with me. My handle is the same as TikTok, and keep in mind that all you have to do is go to the link in my bio and it will take you directly to Instagram. Now, also it can take you to the website where you can learn more about me as the attorney, the law firm, what I have done, and you can get in touch with the law firm to schedule your consultation because the information here I'm giving you is general information. It's not personal legal advice. So you want to make sure that you are covered and that if you are in a situation that you're about to apply. That's so important. You're about to apply for an immigration benefit. You want to make sure you're on the right track. You want to avoid mistakes. You want to determine whether you've explored all your options, and a consultation is the right way to go with that. If you marry a U.S. citizen, how long does it take if they file for you to enter the U.S.? So you're looking at about 18 months. Isaac Black, congratulations. Thank you for coming on here and sharing that. I'm always happy to see someone that has reached the end of their permanent residence journey. So thank you so much and congratulations. Thank you. So keep your questions coming, because I am here to answer your U.S. immigration related questions. And back to the topic that I was talking about, in between questions, of course, because I am here to answer your immigration questions. Anything that's immigration related, go ahead and put it in the comments now so that I can answer. But I have been addressing that question that I get ever so often in consultations, in the comments, and it's how can I apply for permanent residence or work permit without marrying a U.S. citizen? Isaac Black, you are welcome, and I am glad that my information helped in some way. So thank you for that. That will definitely inspire me to keep on going. So Jay Hines, how long take time to receive interview after you get the work permit? So it's hard to say because it's so up and down right now. The timeline for people getting work permits and getting biometrics, it's all very erratic right now. And so the only thing I can tell you is that you could possibly get an interview 9 months to 12 months, maybe even as long as 18 months after applying. But Jayhine, the best thing to do is go to the service center that's processing your application. And if you go to uscis.gov, click on case processing times, you can find the service center that is processing your case and look at the time range that they are taking. So for the I-485, I'm assuming that's what you're applying for, or the I-765 for the work permit. You can look to see how long they're taking to issue those work permits. So keep those questions coming. Now, I've been talking about how do you get permanent residence without marriage. So there's the employment base. Now, the employment base, I could spend hours talking about it just because there are so many ways to obtain permanent residence through employment. It just depends on your qualifications, on the needs of the employer, and even the needs of the country. So 9 to 12 months after the work permit. So no, not after the work permit, from the time of applying. Now, Jayhine, keep in mind though that every case is different, and so what I'm saying to you is not necessarily going to happen with you. It really depends on your case, and so that's where it's important to get that information based on your circumstances. So check out the case processing times at uscis.gov, and you will have a better idea of the timeline that they're taking, but the entire timeline. It's very difficult to predict how long an interview is going to take after you get the work permit, because everything is so erratic right now that it's hard to predict that. Is it possible to get a work on a visitor's visa and then hope to get a sponsor? Unfortunately not. So when you come here on a visitor's visa, you are not allowed to work, and there's no way for you to get the work permit. You'd have to get another type of visa or another type of immigration benefit that allows you to work. So once you come here on a visitor's visa, you must stay for the time that they've given you. And, I have had cases where if you came on a visit, some people come on a visitor's visa and they end up falling in love and going through and getting sponsored. So that is one very common way that happens. Or they come here on a visitor's visa and they already have relatives here Of course, when they come here on a visitor's visa, it's usually they have a permanent resident, parent or spouse, or a citizen relative. So they're the immediate relative of a U.S. citizen. Now, keep in mind that for a permanent resident to file for you, you would not be able to overstay your status, or you will not be able to leave the country. You'll end up in a very sticky situation. Some people end up in that situation, and that's where it's important to know how to fix that situation throughout the waiver process, which I talk about a lot. So, you know, it's all very complex, but, so if you overstay, does that affect your time frame? So no, Anika, not necessarily. I don't know. Now, when you overstay, right? Usually if you overstay, you would not qualify for adjustment of status unless you're the immediate relative of a U.S. citizen. Immediate relatives of U.S. citizens are spouses of U.S. citizens, parents of U.S. citizens who are 21 and up, that's important to know, as well as children who are under 21 and unmarried. So if you don't fall into that category and you overstay, you will not be able to adjust status in the United States. That means you will not be able to apply for permanent residence while you're in the United States. And that gets to be a very sticky situation, because when you overstay, especially when it gets to the point where you overstay over 180 days, if you leave, you know, if you just say, okay, I'm gonna leave and wait until the process is over, the green card process is over, what happens is that you'll face a 3-year bar if you overstay over 180 days. And what that means is that you will be barred from coming back to the U.S., no visa, no green card, for at least 3 years. It goes to 10 years if you overstay over a year. So in that case, if you overstay, you don't qualify for adjustment of status, you'll need to apply for a waiver. But in order to get the waiver, you'll have to have a U.S. citizen or legal permanent resident spouse or parent who will experience extreme hardships if you don't get the permanent residence. So no, Jay Hines, you're not irritating me at all. But I do want to stress that the information I'm giving you is not particular to you. It's very general information, but feel free to ask your questions. There's no such thing as an irritating question here or even a dumb question. And thank you for the compliment, Jay Hine. How to write NVC by email. So I'm not sure what you would be emailing them about. There are ways to do case inquiries. So if you go onto the website, you will see different tools there that would allow you to contact them directly. So, but I don't know what your situation is, and so I wouldn't know, the appropriate answer to give you about emailing. What state are you locating? So Asha, I'm in Boca Raton, Florida. However, keep in mind, I represent clients all over the country as well as the world. And so I'm not limited by state lines. I'm very experienced with working with my clients to get their cases done. As a matter of fact, immigration attorneys, such as myself, we work with USCIS offices all over the country, immigration courts all over the country, as well as U.S. embassies all over the world. So I'm a USC. My husband overstayed 3 years before we got married, and he's worried about the overstay and if it would affect his paperwork. So generally speaking, spouses of U.S. citizens who overstayed, usually they get a pass. So they're not penalized for the overstay. That is one great benefit of being the immediate relative of a U.S. citizen. And as the spouse of a U.S. citizen, your husband would be the immediate relative of a U.S. citizen. However, keep in mind that this is general information I'm giving you, and so it's very important to get a consultation, especially if you have concerns. Don't go off of guessing. Don't just say, okay, we're just gonna go by the seat of our pants and hope for the best, because that can make things worse. Get a legal consultation to make sure that you do qualify, that there are no additional issues or concerns that will affect your husband's filing. You can, there is a scheduling coordinator who's available up until 11 p.m. tonight to take your call and schedule consultations. I can't stress how important it is to do this and to understand your process, understand what you're getting into, understand whether you qualify, avoid mistakes. So very important. But generally speaking, spouses of U.S. citizens that purely just have an overstay. Now, keep in mind, there are certain types of visas that you can't overstay, and that if you overstay, you will face, you won't be able to qualify. So J1, if there's a 2 year, so the ones that restrict you from adjusting status, some of those, the J1, so that is the J1 with a 2 year foreign residency requirement, and then also the crewmen's, so the crewmen's visa as well. So if your spouse entered with those, definitely take pause and make sure you're going about everything right. Can one apply for a green card if they don't have any immediate family? So yes, there are ways. Now, immediate, you can be the immediate relative of a U.S. citizen. That means the spouse, the parent of a U.S. citizen who's 21 and up, or the child of a U.S. citizen who's under 21. But also, if you're the spouse or child of a green card holder, if you are a green card holder, or if you're the sibling of a U.S. citizen, but there's a caveat here, because if you have a U.S. citizen sibling who wants to apply for you, it's taking a very, very long time. Can a green card holder file for children under 21 who overstayed? Yes. So yes, they can. Now, in this case, though, they would not qualify for adjustment of status. But if the children are under 18, so as long as they stay under 18, they will not accrue unlawful presence. And what that means is that when they schedule that interview at the embassy, if they're under 18 at the time that they go to the interview, the officer will not use the unlawful presence, their overstay against them, and they should be fine going through the process. Once they reach 18, though, and it's 6 months after their 18th birthday, because remember, you start to accrue unlawful presence, that's the overstay, you start to accrue that over 180 days. So if once the child turns 18 years and 6 months, once they're 18 years and they're over 18 years and 6 months, then they are going to have a 3-year bar if they leave the country to attend the interview. But if they're under 18, then you could still go to that interview at the embassy and not worry about the kids being stuck in that country. Now, Latoya, and now is a good time. By the way, now is a good time for green card holders to sponsor their spouse and their children under 21, because there is no wait list for that immigrant visa number. And what that means is that once the petition is approved, it goes straight through to preparing. The National Visa Center prepares the application and then sent it to the embassy for the interview. So now is a good time. So Latoya, call, schedule a consultation. Let's talk about the process for your children under 21, and then hopefully get started right away. Now you can go to the link in my bio where you can go to the website. There's a contact information, a contact form that you can complete. You can also call the scheduling coordinator to go ahead and schedule your consultation. So sorry, I didn't clarify well. I don't have any sibling nor spouse in the US. I'm from Africa. So in this case, here's one thing. It's like the lottery for the green card. Every year, the Department of State opens up the site, and if you sign up, you may be selected. And if you're selected, you can, and over a year, they'll process your case. And if your case is processed after that year, you could possibly become a permanent resident. Latoya Henry, I'm looking forward to seeing you. Now, I'm going to take this conversation over to Instagram right now. So all you have to do is go to the link in my bio, click on the Instagram button, and it's going to take you to the page where you can follow me and then tune into the live. I'm going over there right now. Thanks so much, guys, for tuning in, and I will be back tomorrow. So if you're not joining me to continue the conversation on Instagram, I'll see you tomorrow at 9 o'clock. So just follow me and keep an eye out when I am back on live at 9 p.m. Eastern Time tomorrow. Have a good night, everyone.